That's it.
I
We're
think
all set.
Oh, you're there.
we're ready for kickoff. Okay, Crystal, why don't you, if you have to do anything with the computer people before we go, otherwise I'll start the meeting.
We are all set. I already started the recording, so good to go whenever you are.
Okay, that's great. Then here we go. I apologize for the difficulties and hope I stay in your presence for the rest of this hearing. We're going to call to order the hearing dated January 4th. This is a 7 o'clock hearing, and it's on the it's an appeal brought by Mr. Joe Henning and Mr. Rowe, pursuant to Chapter 48, Section 8 of the bylaws. They sent a request for a zoning enforcement to the building commissioner on September 28th, 2002, alleging that Thayer Nursery was continuing to operate a large-scale commercial landscaping and construction and firewood distribution business on the property without a permit. The building commissioner did not act on Mr. Dunn's letter, and therefore Mr. Dunn has brought this appeal on behalf of Mr. Rowe and Mr. Joe Henning. My name is John Leonard. I'm chairman of the Board of Appeals, and with me this evening are board members Jeffrey Mullen and Ted Daber. We will have as record evidence at this hearing the application which was filed by attorney Matthew Dunn of Boston, Massachusetts, dated November 2nd, 2022, and attached to that application is a September 28th, 2022 letter of attorney Dunn to Mr. Prondak, alleging what he believes to be impermissible activities by Thayer Nursery Corporation on the site. We also will have as evidence at the hearing a January 3rd, 2023 letter of Mr. Dunn to the Board of Appeals, setting forth the substance of what he believes the evidence will show at this particular hearing, and that Thayer Nursery is not entitled to be operating a commercial activity on the property in the nature of a commercial landscaping business. Mr. Dunn also filed with the Board of Appeals a letter of January 4th, 2023, which I think is today, setting forth a series of exhibits that he has filed with the Board of Appeals in support of this application. The exhibits were sent into basically a lockbox type of system. Let me ask you, Crystal, have these exhibits been put on the website as of the present time?
They have, the ones from today have not yet, no.
Yeah, and that was my concern, because unfortunately, while these exhibits, I guess, have been filed with the board, in order to access them, you have to go into the lockbox, and we usually publish all of these exhibits on our computer system, so they're easy for members of the public to see. I'm not sure any member of the public would have access to these documents at the present time, and that's a matter of concern, and we can discuss that as we go along in the hearing. We also will have evidence at this particular hearing the decision on cross motions for summary judgment in the land court in the case of Mr. Joe Henning and Mr. Rowe against the Milton Planning Board. That decision is a decision of the Massachusetts Land Court, Judge Diane R. Rubin, and it's dated August 10th, 2022. I think that probably should be on our website. And we also have an appeals court decision in case number 19P1224, a memorandum in order dealing with the appeal of Mr. Johanning and Mr. Rowe of the land court action. And that is dated August 21, 2020. Crystal, do we know whether the decision of the land court and the appeals court memorandum, has that been placed on file at the on our computer system?
I'm unsure. Those are a little bit older, though, those documents, correct?
Yes, they are. Yes.
Yeah, so they should already be on there. It's just the ones that I just received within the past 24 hours that
Okay.
are not.
Now we'll do the best we can and see how we proceed here. As I indicated, Matthew Dunn is representing the applicants. Mrs. Marion McGettrick is also present this evening. And Marion, just for the sake of the record, whom are you representing at this particular hearing?
I'm representing Josh and Maggie Oldfield.
Okay, are you representing Thayer Nursery Corporation? Yes.
Yeah, I guess so. Yeah, yes.
Okay, so
We
you
haven't really
represent.
discussed it per se.
Yeah.
Yes,
Okay, and we also have present Attorney Kevin Freitag, representing the town of Milton. And I see Mr. Prondak there, our building commissioner. So I think that's probably a fair explanation of where we are. So I guess I'll ask Mr. Dunn, do you want to make an opening statement, or are you just prepared to proceed and present your case?
I'd like to make an opening statement. It's good to see you again, Mr. Leonard.
Good to see you as well.
It's been a while. It's good to see the members of the board and Ms. McGettrick. Just to clarify a few points here, Mr. Leonard. The zoning enforcement request was submitted back on September 28th. It looks like Mr. Prondak's response in our appeal may have crossed in the mail. He did file a response. I didn't get it by the time we filed the appeal, but it was provided to us and it was dated October 31st. I'm not sure if the board has a copy of that.
I personally do not have it. Jeff Mullins, you have a copy of the Joe's decision of October 31st?
I do not.
And Mr. Daver?
You're on mute.
Ted, you're muted. Do you have a copy of Mr. Prondak's letter decision on October 31st?
Yes, I believe I do.
Okay, well.
Someone sent it to me. I can't, it obviously wasn't you. Maybe it was Crystal.
Okay, well, I assume that Mr. Dunn, I assume Mr. Prondak's letter was fairly short and succinct.
Yeah, and it gets us to the same place,
Okay.
which was his decision not to enforce, bring an enforcement action as against Thayer, which, brings us here anyways. So, it's helpful to understand Mr. Prondak's rationale. But at the end of the day, it's still a decision that we would have appealed nonetheless. So whether it's a constructive denial or an actual denial, it's still a denial. And, we're ready to proceed with the appeal for this board.
Then that's great. Why don't you continue with your opening statement or start your evidence?
Yeah, so just to bring everybody up to speed, I know that this has been an issue before the board and before the town as a whole for quite some time. It's been the subject of a couple of different lawsuits over probably the last 9 years. And where we are at this point is there was a bylaw amendment, and I believe it was in 2014, that provided for a special permit to certain eligible applicants to operate landscaping businesses in residential zones.
Yep.
And that was passed by town meeting. It was approved by the Attorney General. It was challenged by my clients in court and ultimately found to be valid. In response, Thayer Nursery Corporation, Maggie Oldfield, and Josh Oldfield applied for a special permit under that bylaw amendment to operate a landscaping business in a Residence A and a Residence AA zone, where Thayer Nursery is operated. That was originally granted in 2016. The decision was challenged by my clients in the land court. The special permit was to all three of the applicants, was originally affirmed. And that decision was appealed to the Massachusetts Appeals Court. In the appeals court action in the 2006 special permit, which lasted it had a duration of 3 years, that special permit. The appeals court ultimately found that Josh and Maggie Oldfield individually were eligible for a special permit under this bylaw amendment, but that the Thayer Nursery Corporation was not. Fast forwarding to 2009, because there was an expiration date on the original permit, those same three applicants applied to renew the special permit that was granted by the planning board. That decision was challenged by my clients. In response to that, and during the pendency of the litigation, the appeals court decision came down with regards to finding Thayer Nursery Corporation ineligible. And ultimately, in the 2019 lawsuit, Judge Rubin of the Land Court again found that Josh and Maggie Oldfield individually were eligible for a special permit to operate a landscaping business in this Residence A and AA district, but that based on the appeals court decision, that the Thayer Nursery Corporation was not. And so that decision came down in August of 2022. It was not appealed, so it's now a final judgment. And so what you have left is you have Josh and Maggie Oldfield individually being eligible to operate a landscaping business on the site, and Thayer Nursery Corporation being ineligible to operate a landscaping business or any other commercial venture on the site, based on the appeals court and land court decisions that they were ineligible for a special permit, which is what's required to operate those commercial ventures in the Residence A and Residence AA district. And so it came to our attention that Thayer Nursery Corporation was continuing to operate these commercial ventures in these residential zones, despite the fact that it was ineligible for the special permit. That is what prompted the zoning enforcement request to Mr. Prondak. And again, Mr. Prondak ultimately did, it looks like he spoke to Miss Oldfield and Josh Oldfield, and ultimately came down with the decision not to bring an enforcement action against them. That is the subject of this appeal. And the appeal is it really boils down to this. You're probably going to hear an argument that Josh and Maggie are operators of the business on that property. And the evidence that was presented to the board today through that Dropbox link, which I understand has not been uploaded to the Town of Milton website, and I apologize for getting that information out, on the day of the hearing, but it took some time to assemble. But what you're going to see is really what's happening on this site, which is as follows. Maggie and Josh Oldfield are the officers, directors, and directors of the Thayer Nursery Corporation. It's the Thayer Nursery Corporation that operates the commercial businesses in the Residence A and Residence AA district. So what I suspect you're going to hear is an argument that sidesteps the fact that Thayer Nursery Corporation is the actual entity that is operating the business on the Thayer Nursery site. And you're going to hear that that's Maggie and Josh. But again, Maggie and Josh are agents for Thayer Nursery Corporation, and it is Thayer Nursery Corporation that is operating the business in the residential zone. And it is Thayer Nursery Corporation that both the appeals court and the land court said was ineligible for a special permit, which is the only way that these commercial ventures can operate in those residential zones for the special permit. So the actual entity that's running the business is precluded by the appeals court and the land court from running the business in that location. Now, if Josh and Maggie Oldfield wanted to run that business in their individual capacity, both the appeals court and the land court have indicated that they could do that. But that's not what's happening. And the documentation that's been presented in the submission of today indicates, it gives the board some pretty clear evidence that Thayer Nursery Corporation actually leases the Thayer Nursery site. Thayer Nursery Corporation, as indicated by records on the with the Massachusetts Secretary of State, has its principal place of business on the Thayer Nursery site.
I'm sorry, can I ask you one question, Matt?
Sure. Yeah.
You say Thayer Corporation leases the site. My question to you is, to whom does that lease run?
To the individual Oldfields. It actually runs to, if you just give me one moment, I can tell you who it runs to. Margaret Oldfield and the Oldfield Family Trust have an Agristar lease for 270 Hillside Street, 0 and 24 Forest Street in Milton, Massachusetts, in favor of the Thayer Nursery Corporation. So Thayer Nursery Corporation controls the site. Thayer Nursery Corporation operates the business on that site, as is represented to the Massachusetts Secretary of State's office. It's represented, it's attested to by both Josh and Maggie Oldfield in the affidavits that I submitted as exhibits 2 and 3. Well, I'm sorry. The lease is exhibit 1. The corporate filings that go back to 2002 that long predate the 2013 eligibility requirement indicate that Thayer Nursery Corporation has been the entity doing business at 270 Hillside. Exhibit 3 is an affidavit from Josh Oldfield dated June 22nd, 2016, in which he indicates that Thayer Nursery Corporation is operating on that site and that he is the president of that corporation. Same thing with the affidavit of Margaret Oldfield dated June 23rd, 2016. That's exhibit 4. There's been representations to in the 2000 by Maggie on behalf of the Thayer Nursery Corporation in the 2010 Agricultural Composting Registration Annual Report that the operator on the 270 Hillside and Forest Street is the Thayer Nursery Corporation. That same representation is made in 2011, 2012, and 2013 on the Agricultural Composting Registration Annual Report submitted by Thayer Nursery Corporation. There's a representation that Thayer Nursery Corporation operates on that site in a workers' compensation and insurance affidavit submitted by Josh Oldfield as president of the Thayer Nursery Corporation, dated January 30th, 2006. So this has been some time. And then there are numerous representations, and this is why I submitted it, that explain the operation and the structure of the Thayer Nursery Corporation and the business that are made by Margaret Oldfield, Maggie Oldfield, in her deposition transcript that's submitted as exhibit number 10. Now, on top of all that, Mr. Prondak has the ability, per the terms of the bylaw amendment that makes that provides for the eligibility of a special permit to qualified applicants, the right to go and inspect the records of Thayer Nursery Corporation. And I believe that there's an annual requirement to do that. I haven't seen any indication that that's ever been done, but if it was done, I think there's got to be some clear evidence to Mr. Prondak that it's Thayer Nursery Corporation that's running Thayer Nursery in the Residence A and AA district. And so to sort of, again, to boil this all down, you have you need a special permit to operate these commercial ventures in the Residence A and residential AA district. Their Nursery Corporation does not have that special permit. Their Nursery Corporation is operating commercial ventures in the Residence A and Residence AA district. Maggie and Josh Oldfield are not their Nursery Corporation. Maggie and Josh Oldfield are not the operators of the landscaping business on that property. Maggie and Josh Oldfield are the operators in the form of directors, officers, and employees of the Thayer Nursery Corporation. And the Thayer Nursery Corporation is ineligible to operate those commercial ventures in the Residence AA district. So I know that it's got a very long history and it can be somewhat confusing, but if you follow the decisions of the appeals court and of the land court, and it's particularly the most recent decision of August of 2022 from Judge Rubin that affirmed the appeals court decision that their Nursery Corporation was ineligible for the special permit, and understand that the special permit is what's required in order to operate the commercial ventures on the site, then the evidence that's presented is somewhat overwhelming in that it is this entity that is operating the business, and it is not Maggie and Josh that are running the business. Maggie and Josh are running the corporation that runs the business. So that's our argument in a nutshell. I'm happy to field any questions or or yield the floor to Ms. McGetrick or to any board member that'd like to take over. But that's where we're coming from. That's a summary of what the documents that I submitted to the board reflect, and would ask that respectfully, and I understand Mr. Prondak's position completely. I respectfully ask that the board overturn his decision and direct an enforcement action as against the Thayer Nursery Corporation. Thank you.
Let me ask you this question, Matt, if I could. What if Maggie and Josh Oldfield formed an LLC or some other corporate entity located on the subject properties and accounted for their landscaping business as a separate entity? Would that cure all of the problems here?
No, because the limited liability company itself would have to apply for the special permit under the bylaw amendment, and they would not be eligible for that, because one of the requirements under the bylaw amendment is that you have to hold rights in a special permit prior to 2013.
Right,
And
but
so-
don't Josh and Maggie qualify under that particular standard?
Josh and Maggie individually do, and I'm going to tell you why. Because
But they don't have a right to operate under a corporate structure as part of their business operations.
they're not operating under a corporate structure. The corporation is operating the business. And that's what all the documents that you're going to review.
But doesn't the decision that Judge Rubin filed indicate that individuals, while eligible for a special permit, still can operate under the I'll say the guise, I don't mean it in a nefarious sense, under the blanket, under the penumbra of a corporation? They're not required to specifically be individual and personally liable as an individual in order to qualify for a special permit. Is that fair?
I don't think that that's correct. I think that there's stacks of case law that I indicate that a corporation is a separate and distinct legal entity from the owners. And so I think that there is some confusion with regards to missing the middle piece of what is actually transpiring here. Yeah.
Was that confusion Judge Rubin's confusion and not appealed from or not clarified in any of the subsequent decisions?
Well, I think it's been an issue that hasn't been addressed directly by the appeals court, and maybe they're gonna get an opportunity in the land court, maybe they're gonna get an opportunity to do that, as a result of this action, but, I think that the fact that an argument that Josh and Maggie can use their individual rights in a special permit that is only transferable to them through language from this board from a 1967 and 1987 special permit that specifically limited the transferability of the special permit rights to these particular individuals. To be able to say that they can use those individual rights and transfer them to a corporate form to operate, to a corporation to be able to operate the corporation on the business, I think that's nonsensical, to be perfectly blunt, because
Didn't Judge, I have Judge Rubin's opinion in front of me, and on page 19, she notes that the appeals court in Johanning number 2 found that the special permit did not specifically prohibit the Oldfield parents from creating or engaging a corporate entity to facilitate or assist them in operating Thayer Nursery. Likewise, Josh and Maggie were not prohibited from using Thayer Nursery to facilitate and assist them in operating the nursery. Doesn't she there say they can do just what you're saying they can't do?
see, I disagree with that.
I'm not saying whether she's right or not, but that's the essence of her finding here.
Well, I think that fails to account for the fact that you have the creation of this bylaw amendment that created this eligibility requirement. This is something that Mr. Jowenning had no part in, Mr. Rowe had no part in, creating this bylaw amendment that basically now controls who can operate a landscaping business in a residential zone. And it has certain requirements. And one of those requirements that didn't exist in 1967 and didn't exist in 1987 is that you had to hold rights in a special permit. And so if Josh and Maggie could operate their nursery prior to 2013 under a corporate form, that changed upon the passage of this 2014 bylaw amendment. And so now you have the bylaw amendment, and now you have the eligibility requirements, and you have the specific language in the special permits from 67 and 87 saying that you can't transfer these things to this corporate entity. And
Matt, don't you have the appeals court specifically finding on page 9 of its opinion that the judge, that the land court judge, rejected an argument that the Oldfield children have not personally operated the landscaping business. The judge reasoned in part that the plaintiffs do not explain why Thayer Nursery would not be entitled to operate through the Oldfield children as it had been under the Oldfield parents since 1967. I mean, when I read this, and I'm not as skilled in these issues as you are, it seemed to me that the appeals court was affirming exactly what the Oldfields are doing under this situation. Isn't that true, or is that I'm missing something?
well, I think
Or do we
that
just have a disagreement on the law that you want to take up to the appeals court or the?
yeah, no, I respectfully, I disagree with that reading, because I think that people are confusing the Thayer Nursery business with Thayer Nursery Corporation, right? So and this isn't really in dispute, right? You have Mr. and Mrs. Oldfield, Josh and Maggie's parents, were operating a business, DBA Thayer Nursery, okay? And Maggie and Josh took over, did not take over that business. Maggie and Josh created Thayer Nursery Corporation to take over the Thayer Nursery business. And so while Maggie and Josh could do business as Thayer Nursery, the Thayer Nursery Corporation cannot do business as Thayer Nursery on that site because they don't have the rights in the special permit. They don't meet the eligibility requirements under the bylaw amendment. So I do think that there's that causes confusion, that the fact that the business and the entity that runs the business have the same name creates confusion. And it creates a misunderstanding as to what is actually transpiring here. And again, that is Maggie and Josh are not running Thayer Nursery. Maggie and Josh are running the Thayer Nursery Corporation that runs Thayer Nursery. And the Thayer Nursery Corporation is the entity that is ineligible for the special permit that's needed to run the business. So if Maggie and Josh want to disregard the Thayer Nursery Corporation and operate Thayer Nursery on that site in their individual capacities, then the appeals court and the land court said that you can do that. But under the town's own bylaw amendment, the appeals court and the land court found that the Thayer Nursery Corporation cannot. And that is the entity that's operating the business on that site. I know
Okay,
it's-
I'm sorry for my questions. It is a confusing situation. Why don't you continue with your comments and any additional presentation you want to make?
No, well, I think that that's it. I mean, as long as the board can understand the background here and how this business is structured in light of the decisions from the appeals court and the land court, which granted, I get it that that's confusing, but at the end of the day, you have Maggie and Josh running the Thayer Nursery Corporation that runs Thayer Nursery in a Residence A and Residence AA district. And that it's that middle entity, the Thayer Nursery Corporation, that is ineligible for the special permit that's needed to run that business on the site.
How do you ascertain and prove whether Maggie and Josh are operating their landscaping business through Thayer Nursery Corporation as opposed to the more generic Thayer Nursery name, which they're operating as individuals?
It's in every one of the documents that I've submitted to the board. And I highlighted the portion where there's representations made by Josh and Maggie. That's the corporation that's operating on that property. Those representations are not only made through their own testimony and affidavits, they're also made through their sworn submissions to the Massachusetts Secretary of State's office and to a series of other entities of the Commonwealth. So, I'm sure they're also on file with the records they're obligated to keep under the bylaw amendment that are accessible to Mr. Prondak.
Okay, I appreciate that explanation. Let me see if my fellow board members have any questions. Mr. Mullen, do you have any questions of?
One question, does the bylaw require that the entity that holds the permit also be the operator?
Well, it's not an entity that holds it's not an entity that holds a special permit.
Or the person, or the person.
The
Does
person,
the holder of the special permit need to also be the operator is my question under the bylaw.
I think that makes sense. I think that's probably.
I understand that you think it makes sense. That my question is does the bylaw require that?
I would say that it does. I think that there's some ambiguity in the way that the bylaw is written on that point, to be perfectly honest with you. So it makes, I think, a clear-eyed reading of that bylaw amendment and its procedural history would indicate that it would make little sense based on the non-transferability provisions in the bylaw amendment itself, that you could be eligible for a special permit and then be able to basically hand off your eligibility to some third party that wouldn't otherwise be eligible, and then they can operate the landscaping business on the premises, which is actually precisely what is happening right now. You have Maggie and Josh being found eligible to operate the business on the property, the landscaping business, not the corporation, and the corporation being found ineligible to operate the landscaping business. And so there's some conflation between Thayer Nursery Corporation and the Thayer Nursery business at 270 Hillside.
Thank you.
Thank you.
Ted, do you have any questions of Mr. Dunn?
Yeah, I have a few and a couple of additions to what you said, Mr. Chair. The documents, and I haven't had a chance to go through all of them. That were filed today, the exhibits that there's a deposition transcript there too.
Yeah, there is.
Yeah.
Don't be sorry there, Ted. They were filed at 2:35.
Yeah,
Okay.
right. It's
Right. Okay, but I mean, were they also? Well, I guess what the deposition was taken in the land court case, I assume.
It was
No?
taken as a separate Superior Court case
Okay.
between the same parties. Excuse me.
Okay. I mean, were the exhibits that you submitted, were they in evidence in the land court case?
Yes.
Okay. So the land court, I think, found in there, despite those exhibits, that there was insufficient evidence to establish that the Oldfields were not individually operating the business.
That point was.
I think that's what I may be inartfully saying it, but I think
that point was never reached respectfully by the land court. What you had is
well, I think there's language in there that basically
the basis of the land court decision from 2022 was basically a res judicata
issue preclusion.
Yeah, based on the fact that
Issue.
we were saying that the Oldfields, the individual Oldfields, were ineligible for the special permit because their interest in that special permit, the 1967 and 1987 special permits, had lapsed for non-use because it was
Right.
their nursery corporation that was operating on the property, not Josh and Maggie.
Right, and you submitted that evidence to show that it was the corporation that was operating,
Right, but
and they said that there was insufficient evidence to establish that it was lapsed.
No, I'm sorry. Respectfully, that's not what it says, because what the point was that point was never reached. The point was never reached with regards to whether or not Thayer Nursery Corporation was actually the entity that was running the business on the property. The Judge Rubin indicated that we couldn't even get to the substance of the argument because we were procedurally precluded from advancing it based on this 2016 case.
Well, they quoted, the land court did quote language from the appeals court decision. Okay, this had to do with an early the one that was being appealed. We discern no genuine issue of material fact on the lapse. The contention appears to be that Josh and Maggie did not commence substantial use of the 1987 amended special permit. And the corporation was actually constructing the business, but the plaintiff's cite us nothing in the summary judgment record supports this proposition. Well, but there's also language in there that Mr. Leonard cited some of the language. It says one or more corporations may be formed to carry out the objectives and purposes of the persons controlling them. That was a quote from the appeals court opinion as well that I wanted to point out. I guess I also want to raise a question or raise. I was looking at the purpose. The purpose of the bylaw. Let's see, out of the bylaw amendment, I'm sorry, not the bylaw. It says the purpose of this subsection is to permit the ongoing operations of landscaping businesses which were in operation on July 2012 and which existed on lots for each one of which is special permit. So permit the ongoing operations. And as of July 2012, you know, it kind of troubles me. I think the corporation, according to you, and I guess according to what you've submitted, was participating in the operations or was being used by the old fields to conduct those operations. And the purpose was to permit the ongoing operations. So I'm not, you know, to me, it's, you know, it could be interpreted to mean that it's, you know, to permit the ongoing operations, including the use of a corporation. I mean, what do you have to say about that?
So I think that reading, and I understand where you're coming from, but again, I didn't write the bylaw amendment, but the
No, I don't either.
yeah, but to only look at the purpose would read out completely read out the eligibility requirement of that, and that wasn't something that, you know, the eligibility requirement was something that the head of the planning board, in conjunction with another attorney, included in that amendment, which was submitted as a citizen's petition to the town meeting. And it does exist and it serves a purpose. And the purpose of that is to make sure that, you know, this wasn't just designed, and, you know, I've been told repeatedly, and submissions have been made to the appeals court when we challenged this as spot zoning, that this amendment wasn't just for Thayer Nursery Corporation, that this was a general amendment, that there was numerous, at least 5 landscaping businesses in town that needed this amendment in order to continue operating. And Thayer Nursery Corporation just happens to be, I guess, the only one who sought relief under this specific provision of the bylaws. But in any event, there is an eligibility requirement to make sure that, you know, not every Tom, Dick, and Harry can operate a landscaping business in a residential zone. And the appeals court and the land court identified that the Thayer Nursery Corporation, ironically, wasn't eligible for the special permit that the bylaw amendment that it sponsored made available. And so I guess the short way to answer your question is, I understand the purpose. It's not specific to Thayer Nursery Corporation, which is why there's the existence of the eligibility requirement that's been enforced by both the land court and the appeals court.
Okay, thanks. Yeah, I guess that gets back to the question that Mr. Mullen raised. You know, the eligibility requirement, and I guess the land court decision said that it could not be the corporation could not be a holder of the permit. And then the question becomes, does that prevent them from participating, the corporation from participating in the operation of a business, even if it doesn't hold the permit? Or prohibit the, you know, the individual holders of the permits from using a corporation as part of their operations, the centralized operations or something. Anyway, those are my comments and questions.
Thank you.
Thanks, Ted. Appreciate very much. So, Kevin Freitag, do you have any questions of Mr. Dunn?
Mr. Chair, thank you. No, I do not.
Already. Let me ask Mrs. McKettrick, do you have any questions that you want to ask Mr. Dunn? regarding his presentation. And
I have comments that I'd like to make. They aren't really questions. Shall I reserve those?
yeah, why don't you reserve them and we'll keep sanity.
Thank you. No, I don't have any questions.
Okay, thank you, Marion. Let me just ask Mr. Prondak. I know part of the difficulty here is that we have the issue raised in the application. And you know, the issue is raised there, but none of the supporting materials are really incorporated as part or as schedules or part of the Board of Appeals application. And then you did your response, for which we thank you. And then after that, the response was filed, this appeal was filed, and then we have this onslaught of corporate documents and decisions of the courts, and none of which I believe were presented to you when you were making your decision on the application for a zoning enforcement that Mr. Dunn filed on November 2nd, 2022. So in a sense, I guess I'll ask you a broad question, whether you have any questions here or whether you have anything to any comments that you want to make regarding your action or lack of actions on the enforcement action and on the legal issues that we're discussing here. I know you probably haven't had a chance to go to this Dropbox and review all of this stuff.
Mhm.
I certainly haven't been able to do that. But did you have any questions, Joe, that you want to ask or anything you want to say? Or
Well, I'd like to add something to just clarify my decision. I think it might make it easier if you look at, if you do have Judge Rubin's decision on page 8 in section 12, and Ted talked about the purpose. The purpose goes on a little bit further, and this is why I made my decision the way I did. It says that this section is intended to make the physical layout and day-to-day operations of the nursery compatible with the neighborhood, basically. Josh and Maggie Oldfield do the day-to-day operations. When we talk about who's operating the business in line with the special permit, in line with the bylaw, we're talking about the day-to-day operations. Who does the physical work there? That's Josh and Maggie. The bylaw doesn't address how the business is run or what entity might help with the running of that business. It's the day-to-day operations that I was focused on, and that's why I made my decision. And I think you know that it's not necessary for me to review who's involved in Thayer Nursery or how Thayer Nursery is set up, because the special permit is entirely about the day-to-day operations. So that would be my comment.
But Joe, let me ask you this: is the special permit relating only to the landscaping aspects of the Thayer Nursery business, whereas the nature of Thayer Nursery's business is broader than the landscaping? It includes other matters and other issues.
It does, yes. I think if I'm understanding the question
Yeah,
correctly.
well, I'm not sure the question's a good question, but it seems to me that if and it may be just a lack of specificity and a lack of clarity that somehow the special permit holder, in order to make clear what's being done with respect to the landscaping aspect of the business, and I guess the selling of firewood as well, that do you know how that's accounted for in the Thayer Nursery Corporation structure? Is it segregated out or is it all mushed up?
I have no idea on that. Again, my focus is on the day-to-day operations of the landscape business as outlined in the bylaw. And that at any time I've ever visited the site, anytime I've ever had any discussions with the site, it's always been with Josh and Maggie individually. And it's from what I could see, with my limited knowledge of the judge's decision, Josh and Maggie individually are eligible.
Okay, thank you. It may just be that we have to, and will, go through the documents that Mr. Dunn has submitted in the Dropbox and see if we can make those types of distinctions and whether it's sufficient clarity exists. Mr. Dunn, do you have anything else further you want to add to your?
Yeah, and I understand what Mr. Prondak is saying, but I think it's also important to point out that it's not Josh and Maggie Oldfield, two people operating this business on this property. This entity employs over 20 individuals. It has at least 11 vehicles on site that are all registered to the Thayer Nursery Corporation. So, I think that the issue before this board, and after you get an opportunity to review the documents, which again are going to show that it's Thayer Nursery Corporation that's running Thayer Nursery on this property, is and I think Mr. Mullen kind of zeroed in on it, is whether or not Josh and Maggie can use their rights in the special permit and basically transfer them over to Thayer Nursery Corporation to run the business, even though Thayer Nursery Corporation in and of itself is ineligible to run the commercial ventures on that site.
Right, but don't they have the right under these decisions that we've been discussing I'm not saying it's the preferred way of doing business, but to rent, for example, 5 vehicles in order to do landscaping projects, or in special needs to rent front-end loaders or whatever, as long as it's Josh and Maggie that are doing the business, whether it's the
See,
thing.
that's where the, respectfully, Mr. Lynn, that's where the disconnect occurs. Because there's a difference between the business and the entity that's running the business, right? So you have Thayer Nursery that is in the business of doing all these commercial things, and you have Thayer Nursery Corporation that is running that business. And you have Josh and Maggie as being employees, directors, and officers of that business, of that entity that's running that business.
It seems to me what you may be saying is the Oldfields and Thayer Nursery Corporation may be not properly accounting for their various activities in a manner that's consistent with the law of special permits. But I'm sure you're not filing this action in order to help Maggie and Josh be more precise and perhaps more businesslike in setting up their landscaping business. I mean, that may be the end result of this. But it seems, even if you're correct on your documents, if that's what they show, that maybe it's a lack of technical understanding by Miss Josh and Maggie Oldfield as to how they have to technically account for and proceed if they're using Thayer Nursery's equipment and personnel and all of that, and whether that type of activity is
I don't think that they need my guidance. I think they completely understand exactly what they're doing. And it's worked out for them so far.
Yeah, but
Um,
what if they make, if they contact some very fancy corporate CPA who tells them to, form another corporation here and you account for it this way and to keep your books, so you're doing this and that. I mean, it sounds like at the end of the day, this is something that I can't imagine a land court judge or an appeals court judge wanting to get involved with, is saying this is something that the proper accounting practices and a
I
proper.
don't think, yeah, I think you're, respectfully, Mr. Leonard, I think we're sort of, the focus on this is whether or not their nursery corporation is allowed to operate that business in the residential AA and single A residential zone. And the land court and the appeals court indicated that they're not. And it's just really whether or not.
That's not what they-
I don't think that's fair.
That's
I
not what
think-
that is what he's, like, maybe I'm reading the decisions wrong, but I seem to read that judgment to say the special permit that issued to Thayer Nursery Corporation is annulled. And so
Well,
I
but
don't
that's-
understand why or how Thayer Nursery Corporation can continue to run a commercial landscaping business and all the
Because
commercial ventures on the property without the correct zoning to do it. I mean,
because
if you,
they're making the assumption that that's what they're doing. That they're saying, and perhaps inartfully, and perhaps not procedurally properly, but we're running the landscaping business. And yes, we're using we're hiring some equipment and using perhaps some personnel from Thayer Nursery in order to conduct the landscaping business. And you're saying, well, the documents show that.
that's a complete fiction. That's a
And
complete fiction.
we're saying that we've got some fancy CPA from downtown Boston that's going to change their books and record keeping and all of that. And then they think they're in business. You say they're not, and off you go to an appellate court, to the land court.
No, there's a sound financial reason why Thayer Nursery Corporation is set up by a Thayer Nursery Corporation that has to deal with tax and liability protections. And there's a reason for it. And so,
Can't they do that by forming another corporation, and let's call it the Prospect landscaping business? Then they can have corporate protect themselves from liability.
yeah, well, I guess I'm asking here, but I mean, does the ZBA, when you issue a special permit to a particular individual, do you allow that individual to then transfer it to a corporation, and then the corporation can use the rights?
As long as they own and run the corporation, that's what the appeals court says they can do. And I think that's what most people would say that they should do. Nobody would recommend, you wouldn't recommend it, but don't answer this question. I'm not trying to put you on the spot. You wouldn't recommend to any of your clients that they run a landscaping business, expose themselves to personal liability. Judge Rubin dealt with that issue, I think, plainly in the decision. I don't know. That's okay. Do you have anything else you'd like to add? I think you've made yourself perfectly clear.
Yeah, no, I mean, I think we understand each other's positions, and this is my client's position. I understand the board's questions and the board's concerns. I hope I addressed them succinctly and accurately. If I didn't, please recall me to answer any questions that you have. But I appreciate.
I think, Matt, to determine whether that's so, I mean, you're a very smart guy. I think you've expressed yourself clearly. And I think the only problem that I'm having, and maybe my colleagues as well, is that regretfully, we received these Dropbox documents at 2:45 this afternoon and haven't had a chance to not only look at them, but to read Maggie Oldfield's deposition and see what issues it related to. So, we're in a state where we need to perform further due diligence to see exactly what you're saying and to apply it to what we think the legal issues are.
I understand. I appreciate that. I apologize for sort of the late dump on the board members. I appreciate you considering our position. I'd also appreciate it if you reviewed the information that I provided to you prior to making any decision, and I'll rest there. But thank you very much, Mr. Leonard and other board members. I appreciate it.
Short of that, so you can be assured of that. Let me, if Jeff Mullen and Ted, you have no further questions of Mr. Dunn at the present time.
No questions.
Okay, then let me switch over to Mrs. McKettrick. Marion, do you want to make a presentation on behalf of your?
Yes, thank you briefly. Interesting discussion. I guess what I would like to say, first of all, is that these arguments, this issue and these arguments were presented before the land court, they were presented in the appeals court, and they were presented in the most recent land court case. So we've heard these arguments before, and we have the decision from the appeals court. We have Judge Rubin, both of Judge Rubin's decisions, including her most recent one. So this is why at this point, I think you're being asked to hear again arguments and evidence that were presented in land court and in the appeals court, and on an issue that has been decided with finality. And that this issue was a very clear one, really. I mean, it's at the heart of the matter. The complainants and Attorney Dunn actually have been talking about the issue of whether the corporation can be involved in the operation of this business since a time before I represented Thayer Nursery, when the planning board heard arguments to issue the initial permit. And they presented a memorandum, and they talked about this particular issue and asserted that, the corporation could not operate the nursery because of the nature of the original nursery permit, and that, but that the corporation was operating and the Maggie and Josh could not be recipients of the permit and so on. So the same argument has come up in each of these cases. And the reason Judge Rubin's most recent decision relied a lot on the issue preclusion aspect was that the arguments had already been made in appeals court, and they had been made in the previous land court decision. The crux of the matter is this: the decisions say that Maggie and Josh can hold the nursery landscaping permit, and that they are personally responsible under that permit for upholding its requirements, that they are and must be the principal operators under the permit. And what the building commissioner is watching for and has been watching all along is whether they're on the site operating the business personally, and they are. The appeals court, however, said very clearly that there is nothing wrong with the individual Josh and Maggie Oldfields holding the permit and using a corporation to assist them in the management of their business. And although the land court did not go into any length about this, we certainly have in all of these court proceedings described the fact that their nursery corporation has been in existence since 1978, when the first nursery permit was issued to their nursery. And so at the time the Board of Appeals granted the special permit initially for the nursery use, they knew of the existence of the corporation. They knew that it was being used to assist with the running of the business. And there is nothing in that original special permit that prohibits the Oldfield parents from using this corporation in the way that they operate the business. So it's been there from the beginning. There's never been a change. Josh and Maggie didn't change the method of operation. And it was the same method of operation in 2012 as is being used now. Those are we've explained these things in these court proceedings. They're in the memorandum that we've presented to the court, and you have the decisions before you. So I would just ask you as a Board of Appeals to consider that you are being asked once again to consider an issue that has already been decided. And the evidence that's being presented to you that you haven't had a chance to thoroughly review is the same type of evidence that was presented in land court and to the appeals court. Evidence that, Josh and Maggie are officers of the corporation, that they signed documents for the corporation, that they've produced reports for the corporation. The appeals court felt that there was nothing wrong with that, and they're very clear in their decision that there's no problem with the corporation being used to help run the business. So that's really the gist of my presentation or argument today. I have reams of material that's been presented in these prior cases, but I don't think that you should really have to do this again. I think you should be able to rely on final decisions by the courts. And so I would just ask you to, when you're done with listening to us tonight, to go back and review the court decisions and all of the evidence that's been provided. And I think in the end, I hope that you would conclude that this issue has already been decided with finality and does not need to be reviewed again by you. Thank you.
Thank you, Mrs. McKettrick. We appreciate your comment. Mr. Mullen, do you have any questions you want to ask Mrs. McKettrick?
No questions.
Mr. Daber, do you have any questions? I'm sorry, Ted, you
I'm sorry. I do have one question. When, Mary, Mrs. McKettrick, when you say Judge Rubin's most recent decision, are you talking about the August decision?
I am.
Okay, thank you.
Ted, you've got the floor.
I have no questions at present. Thank you.
Okay, I don't have any questions presently of Mrs. McKettrick. Mr. Dunn, do you have any questions you want to ask Marion?
No, I don't. Just I don't at all. No.
Okay. Knowing you don't agree with her position, we understand that.
Right. You're right. We do. We see things differently, but I respect her opinion and I understand her argument. I disagree with it, but I understand it.
Mr. Freitag, do you have any questions you want to ask? Mrs. McKettrick? I'm sorry, Kevin, do you have any questions?
No, thank you.
Okay. I suppose I should, Mr. Prondak, do you have any questions you want to ask Mrs. McKettrick?
I do not.
Okay. So all of the principal participants in the hearing have said their piece. Let me ask whether there's any member of the public out there in virtual land who may have a question to ask of either Attorney Dunn or Mrs. McKettrick.
There is no one right now, John, with their hands raised in the public.
Okay.
Mhm.
Mr. Dunn, are you going to be having any other evidence you're going to submit, or is there any other memorandum you're going to submit, or are you content with the present record?
Yeah, no, you have my materials, Mr. Leonard.
Okay, great. And how about you, Mrs. McKettrick? Are you going to be filing any memorandum? If you filed one, let me know, but I haven't seen it.
Well, I have written a letter to the board. It was only submitted last night after reading the materials from the complainants that had been filed. So you will see that in your materials. You may not have reviewed it yet. So
No,
no, I do
I
not plan
haven't.
to submit anything else. Thank you.
Okay, that's great. Let me, so everyone has submitted their evidence, is content with their arguments. And I think we're in a position, let me talk to my fellow board members here, to close the evidentiary portion of this hearing and perhaps to continue it for a reasonable period of time to allow the board to review the case law and to review the materials that Mr. Dunn has submitted in the Dropbox. Do you want to comment on that, Mr. Mullen?
Yeah, I might want to make a friendly amendment to that. That I do think the record is in, but I want to reserve the right to ask questions based on the record and potentially offer or like to offer parties the ability to supplement the record to the extent that's necessary to address the questions that are raised by the board.
Okay, Mr. David, are you content with that suggestion?
Yes, that's actually what I was going to suggest
Okay.
as well.
I
Thank you.
think that's well taken, and I think it is a procedure which protects the interests of both parties here. My next question is to Crystal. Crystal, what? First of all, members of the board, how long do you think you need to review the materials and to get your thoughts in order? 2 or 3 weeks? I don't know what vacation plans are or what your schedules are like.
I don't go on vacations these days.
That's
Sure.
your problem, not ours.
Couple of weeks would be fine. You know, if there were a time limit, I could probably do it in a week, but a couple of weeks would be comfortable, I guess, given the length of what we have to review.
Mr. Mullen, what do you say?
I think that'd be fine.
Okay, Mr. Dunn, how are you with the continuance of this matter for 2 or 3 weeks? I don't know whether that's going to run into your school vacation issues or however you want to handle it.
Yeah, I'd just like to stay away from that vacation week in February, which is, I think it's about 6 weeks away, so.
Okay, so
February should be fine.
okay, and Marion, how about you? Couple of weeks continuance?
That would be, I'll be available then.
Okay, that's great. Crystal, if you're there, do you want to suggest a few dates for us?
Yes, so we could do the 17th, 18th, or the following week would be the 25th. The 24th is not available.
Well, is that
Um,
in February or January?
That is 2 to 3 weeks from now, and then after that would take us into February.
Okay, so January 17th, 18th, or possibly.
Or the 25th.
The 25th is good for me.
How about you, Ted?
Let me double check.
Bear with me, I'm gonna pull up my schedule as well.
25th looks good for me.
Does 7 o'clock still work for everyone?
It does, just hold on 1 second here. I'm
Okay.
having some difficulty with my,
Do you think the Mattapan trolley be running well that night? Crystal, is that what you're suggesting? To get me home by 7?
No.
Have to leave work early to get here.
You have
We
to
can do
bike.
it late. We can do it later.
It's fine. 7.
Okay.
so how about the 25th is a Wednesday. Mr. Dunn, is 25 good for you?
Yeah, that's fine. Yep.
Okay, Marion, how about you?
That's fine, thank you.
Okay, so unless anyone has any further comments, we'll continue this hearing for until Wednesday, January 25th at 7 o'clock, with the understanding that the evidence is basically closed, except for evidence which may relate to questions that the board may have at that time, and it would be our hope and expectation that we could take whatever additional evidence is needed, if any, and be in a position to deliberate on this case on the 25th at 7 o'clock. So with all of that, I want to thank everybody for their patience and their presentations, all of which were very excellent in my view, and for your hard work, and wish everyone a happy new year and look forward to seeing you again on the 25th of January.
Thank you.
That's the
Thank
case.
You all.
Thank you all.
We're
Good night.
adjourned.
Thank you.
Thank you.
Thank you.
Bye-bye.
Nice.
Yep, good night.
Hey, Crystal,
Hi, Joe.
how's it going?
It's going pretty good. How are you?
I'm glad it wasn't 3 hours.
I know, I know.
It could have been, but
Yeah,
that's about as good as we can hope for, so.
yeah.
I'm
I
glad
had
that
a
part's
feeling
over.
it was gonna be continued, so
Wouldn't have been as bad if John had got up and running right away, but.
yeah,
it
that
would've been
happens
only about an hour.
sometimes.
All right, we'll see you at the fort tomorrow.
Yeah, I'll see you tomorrow. Have a good night.
All right, you too.
Bye.